next speech will be made by Sheikh Bilal Khan. So the floor is yours, Sheikh.
السلام عليكم ورحمة الله تعالى وبركاته. بسم الله الحمد لله وحده والصلاة والسلام على من لا نبي بعده وعلى آله وأصحابه الذين أوفوا عهده ما بعد. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. سبحانك لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. Good afternoon, everybody. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.
Thank you for your patience and your perseverance. It's difficult, especially when the day drags on and you have speeches one after the other. Albeit you had a good break, so I hope you're kind of refreshed. But anyway, I have a strict timeline, and the slides are not to follow, it's just a guidance point. So if I want to point you to something, I'll use them, and I'll jump through certain slides. But the idea is to give you a whistle-stop overview of Islamic contract law and sales. Just a whistle-stop overview. So the purpose isn't to make you masters or to go into any details. Inshallah, we'll be here to answer questions today, and inshallah tomorrow there's a conference. And then thereafter we can always, the speakers are here, so we can inshallah refer to all of your matters that you have issues with, inshallah. Three main things. I'm only going to cover the first two, and the following speaker, Brother Farhan, will pick up on the modes of Islamic finance, the application, the theory, inshallah. Contract is in Arabic a aqd. Right, and aqd is something which is another word is ahd. So it's important that we realize these words. Allah says in Quran, Ya ayyuhalladhina amanu awfu bil uqud. O you who believe, fulfill. And this is a command. Complete, fulfill. And this is why in contracts we have a word completion of contract, completion of transaction. Fulfill the contracts. So when you make any promises, or you enter into any undertakings, in any contracts, al-mu'minu idha wa'ada wafa. A mu'min is somebody when he promises, then he will fulfill his promise. Rasulullah sallallahu alaihi wasallam, he in fact had a deal with a person that he will meet him at a certain appointed time, and he came 3 days consecutively for that time, but the other person did not turn up. This was his timekeeping, Brother Yarkal, as you mentioned. So timekeeping, punctuality, keeping your word. If you go to London and you see the city of London, it says, my word is my bond. Yes. There is a line there, my word is my bond.
What was the Latin?
Huh?
Verita,
I don't know, something, yes. I should know that, by the way, but anyway, so my word is my bond. And it's important, and this is what contracts are all about, that they become binding. And parties that sign up to a contract have to fulfill that. This is why Sharia from day one stipulates certain requirements, certain prerequisites that will make you avoid any violations. So, you see, Sharia is something which is according to our nature, fitrah. Yeah, this isn't technicalities. This is not something foreign, alien, incorporated. Sharia isn't here to stifle growth or innovation, rather the opposite. Sharia is, as a catalyst, is here to encourage as much innovation, growth, in any sphere of life. So Sharia is here, and remember the literal meaning of Sharia is also a path. And a path is something, when there's a jungle or treaded path, a middle path gives you a way to get through something. So inshallah, if we follow Sharia in substance, in spirit, as much as in form. Because I think sometimes we get lost in the literal stuff and we lose the meaning of the substance. Substance is very important, that we follow the substance. There's three elements of a contract: the contracting parties, the words of the contract, and the subject matter of the contract. Yeah? So it's important that we realize this. Contracting parties, why do we say that? If you see it from this diagram, you can see there's, at least in a contract, there's two parties. So a contract in Sharia is bilateral at the minimum. Right? If there's one-sided, we call that unilateral undertaking or unilateral offering. That is only a contract if it becomes done under a deed poll. Right? A deed poll is a way to do it. So if somebody does a unilateral offering, a promise, under normal jurisdictional laws, we do that under a deed poll. And how do you do a deed poll? You have to have a witness to execute it. And it's sealed under a company seal, even though there's no other party. In Sharia, we have a Maliki school where Ibn Shubruma is one of the great Maliki scholars, Hatim, and Ahkam al-Iltizam fi al-Wa'd. This is a great book of the Maliki school where they tell you that even in financial dealings, where there is a liability and some kind of loss possible, then it becomes binding. This is what we have now moved from Wa'd or Ahad from Aqad. And this isn't, you might think this is financial engineering or restructuring. It's not. Because to be honest with you, these things, constructs are there to facilitate deals, trade, transactions. There are certain requirements under each one of these. You can see the subject matter should be specified, it should be quantified. And again, as Dr. Imran mentioned earlier, that is to avoid gharar. Gharar creates uncertainty. And what does uncertainty create? Disputes. So Sharia is all about avoiding niza', avoiding dispute. This is the golden thread through whole of buyur. If you look at the deeper rationale, you'll realize that is to avoid dispute. Sharia isn't for, whereas other laws, certain laws of the land, there is more emphasis on dispute resolution. And Sharia is all about dispute avoidance. Yes, we have mechanisms for dispute resolution, but our contracts and everything is built in such a way that we avoid disputes. Whereas unfortunately in today, people make money, lawyers and others, from taking matters to court and in getting money out of that. Yeah? So crime pays, as they say in the movies. So we want to avoid gharar, we want to avoid uncertainty. And lawyers, it's music to their ears, certainty of contract. Certainty of contract is like music to their ears. And this is why when I speak to lawyers, I don't go through technical jargon or bamboozle them with Arabic terminology. You need to, whoever you speak to, you've got to match with them. Your specialization should mirror their needs, and therefore they'll see the solution. So we have certainty of contract, right? We avoid gharar as much as we can. And with regards to parties, sanity is important. Maturity is important. Remember, these are requirements at the time of the sale, at the time when the contract has been entered. Somebody can always turn insane later on. That's not in your control. And obviously we have certain conditions and wording, and they should not be contingent. As you can see at the bottom, it says contingency. You can't say that this contract will only take place contingent upon a certain event taking place. Whatever that is. Recep Tayyip Erdogan winning the next election. Or Besiktas or Fenerbahce winning a certain match by a certain score. We don't do that, because that is not something, we don't have that chance. Then brings Macer into it, because chance is all about speculation, right? We have speculation then, and the whole thing is, even as Dr. Imran mentioned earlier, insurance has a lot of that. This is why insurance contract, the wording is problematic, because there's contingencies in there. The speculation is manifold. Number one, the insurer is actually gambling and speculating that there will be no claims this year. So you see that kind of element. And also on the asset side, there's also problems there, because what kind of speculative instruments they invest into. So these are problematic things. we mentioned that, just the last part, the words of the contract, they can be spoken, it can be an oral contract, or it can be written contract. So it doesn't just have to be written, in the sense. Why we say that? Because sometimes, when you go to a shop, a store, like one of these supermarkets, it's a contract when I go and buy something. I don't have to always have some kind of written contract saying there's been an acceptance, there's been an offer. It's market practice. This is the evolution of Sharia. Sharia is a law system. The closest example I can give is the law of, say, common law, which is based on a precedent system, as opposed to the US law, which is very much codified. So the US has a code system. Everything, whatever's there, is the only law. Anything outside of that, they struggle with that. And that's why you'll find they've got new laws coming up, the FATCA and this and that, and all of those things. And whereas we're saying it's an evolution. So anything which is, as long as it doesn't go against the tenets of Islam, the teachings of Quran and Hadith, Sharia will say al-ma'ruf kal-mashrut. Anything that's out there in the market, in the practice, provided it doesn't not only violate the Sharia, but doesn't go against the party's interests. Because parties are kings here, really. When you enter into a transaction, Sharia gives you freedom. إِلَّا أَن تَكُونَ تِجَارَةً عَن تَرَاضٍ مِّنْكُمْ. Sharia says that don't eat, لَا تَأْكُلُوا أَمْوَالَكُمْ بَيْنَكُمْ الْبَاطِلِ إِلَّا أَن تَكُونَ تِجَارَةً عَن تَرَاضٍ مِّنْكُمْ. Do not enter into a batil contracts unless, and look at this, the exception Sharia provides, those deals and transactions where the parties mutually consent. So a consent is important, and that allows you freedom. Yeah. So they should consent with each other, and this is very important. Mutual consent of the parties. Subject matter of the contract. Now, the property has to be of value, right? The property, and when we say value, Sharia doesn't recognize haram things as value, number one. Right? So that's not value at all. And number two, anything that's on the side, I can't go and sell some stones or bricks on the side that has no value and is nobody's property. It has to be valued. It has to be owned. Ownership is very important. And this is why there was a big issue, not only Islamic finance, put that to a side, even in conventional industry when the last collapse happened. Do you remember when Lehman Brothers collapsed, the big bank? One of the biggest issues that came out was the true sale issue. The law firm Allen and Overy gave a legal opinion that the dealings were based on true sale, that there was really transfer of ownership. When they went and studied, and PricewaterhouseCoopers was involved in this, and also Allen Overy, they realized there wasn't real transfer of ownership. Why? It's because ownership is only ownership when risk of ownership follows. If the risk of ownership isn't with me, then I'm not really an owner. And there shouldn't be any inhibitions, any restrictions. Sometimes there's banks or other institutions that may put charges on, restrictions. Now we need to realize, is this free? Because you need to discharge that mortgage, that charge over that property, and then sell it. And also make sure that there's rights. But when we say rights, there could be a matrimonial home. A home, matrimonial, husband and wife. Sharia also recognizes that a husband and wife both have rights. So the husband can't sell because by implied term, not express term, implied term, the wife has rights. So you can't sell somebody else's house. See the hikmah? Sharia is designed to protect everybody's interests. You cannot, somebody came to me once and he said, oh, and just a side anecdote, I've read the IOFI standard and it says may here, can we then do something? I said, this Sharia isn't like a normal law that you can find loopholes and play with the words. This is, the Sharia standards were designed, IOFI Sharia standards, for argument's sake, were designed to be simplified. Something that anybody are user-friendly, easily understandable. That doesn't mean that that's the only law. There's fiqh behind it, there's research. Only an alim, a scholar, a faqih can work on that. Yes, the industry uses Sharia standards, but if you ever get confused, you should go to a scholar. Not open the Sharia standard yourself and say, oh, I think this is this, therefore you can do. The example I want to give you is AIG. AIG, one of the biggest insurance companies, they were trying to do read the takaful, and there was some issues about how much they should keep. They were keeping 95% and ceding 5%. So it's problematic because then there's risk transfer going on. So there's a lot of issues. We've got to be very careful, and this is why you need Sharia scholars. Sharia scholars are not there just for dressing up, are not there just for credibility for third parties and sit on your board. Really, a sound Sharia board, a good Sharia scholar will guide you through a lot of pitfalls, a lot of holes, will avoid all of that. Two types of contracts. There's those that have, as mentioned earlier, those that have compensation, consideration, that have bilateral. They come in the form of, say, sale or ijara. Those that are unilateral will be like gift, loan, even a promise is unilateral. We spoke about conditions and how important they are for the validity of the contract. You can see here, a condition will only be valid if it's not against the contract. If it's against the contract, then you can't. I'll give you an example of nikah. You can't say, put a condition in nikah that I'm only marrying you for such and such a time, right, or for a week, because then that goes against the contract, the whole purpose of the contract. So the validity has to be in line with the ethos. How much time do I have?
Another 10 minutes.
Yeah. Then a condition which seems to be against the contract, but actually is in market practice. This is what I said earlier, is not void or voidable, provided that voidness is not proved to be against the injunction of Sharia. Remember, always the drawing board, whenever you are confused, whether this is in line with this particular ruling or that or not, you go back to the basics. And that a scholar will take you through. Because scholarship isn't like a law degree. And I think it's important that we explain this. Sharia scholars are not just people who do 3-year degree in accountancy or finance. This is very, very rudimentary, traditional training in all kinds of sciences related to Quran and Hadith. And then you have to do it under the supervision of a jurist, a scholar. It's training. You can't just study, say, medicine yourself and then start saying, I'm going to do somebody's surgery. Nobody will let you do surgery because you have to be trained, supervised, and then even senior doctors watch you and surgeons watch you. Same as Sharia. A good scholar will be like that. Unfortunately today, anybody who knows a few words of Arabic is a scholar. And this is where the problem is, to be honest with you. And they're sitting there giving injunctions and telling you this is halal and that's haram. This is where the problem comes. That was an example of the first one. A condition that is against the third one, against the contract, not in market practice, but is in favor of one of the parties or the subject matter, that condition can still be void. And this is an example. If A sells a car with a condition that he will use it on a fixed day every month, you can't. Because when you sell something, you transfer the ownership. You can't fix it and limit it. There's no limitations in that. Fourth one, a condition which is against the contract, not in market practice and not in favor of the contractor, that is not a void condition. How can that happen? Look at this example. If both A and B decide to give some money to charity, a percentage, so two parties come into a transaction, they say, well, we want to give this much, they're free to do that, because you can't say, well, this is not possible. We've covered some of this, I'm not going to go over this. Very basic kind of rules that we've covered. Right. Dr. Imran mentioned about Bay Fasid and Bay Batil earlier, so this is where he was referring to. There's 4 types of sales. Bay Sahih is the valid sale. The one that's Batil is something that's non-existent. The Sharia doesn't even recognize it as existing. Fasid is there, that does exist, but because of some invalid condition or some malpractice, it becomes defective, it becomes Fasid. And sometimes a bay becomes makruh, dislikable, abominable, because of whatever, let's say it's doing a deal at the time of Jummah prayer, those kind of examples, or doing a deal in a time where it's salah time, general salah time, or shouldn't be doing something practice, it's dislikable. For example, if somebody is fasting and you go and sell in the daytime to them, try to sell to them, again, it's dislikable. It's not haram, but it's dislikable. We're going to rattle through this because this is very self-explanatory. You will have access to these slides anyway afterwards. In terms of valid sale, these are the 4 key elements that you need to know. So the contract itself has to be there. There should be a subject matter, something you're selling. That's why you can't sell something that doesn't even exist. You can't say, oh, I'm going to sell you some kind of promise, something that's not even in existence. There has to be a price If the parties haven't even determined the price, haven't even discussed the price, there is no sale, right? This is why some people who buy wholesale from different countries haven't even agreed the price and trying to sell it to a third party before. It's not acceptable. And also there should be some form of delivery or possession. Now until you don't have that possession, it won't work. That is more kind of the same thing but in a diagrammatical fashion. Here, as you can see, the contract itself is two types. I said this earlier. It could be oral or it could be implied. And oral is when you say something. Implied could be when you're pointing at something, or when it becomes a market practice of doing. So if I went to the shop, took a case of Coca-Cola or something, took it to the counter, the fact that I've made this action, and this is a practice normally, I don't have to say I want to buy the person, I'll accept your offer. That practice is implied, right? So really, what we should have called the first, we could call it express and implied, as two terms there. But anyway, you can play with these slides and use whatever works for you. Buy and sell, we mentioned that they should be sane and mature. Conditions of the contract, sharaa'it of aqd, these are important as well. Sale must be non-contingent. That was discussed earlier. I gave an example. It should be immediate. It should be instantaneous. You can't say I'm selling you this now in a month's time. The actual mabir, right? This is the goods that you're selling. There's some requirements for that as well. It should be in existence. So something that's not in existence, you can't sell that. It has not even been made yet, or it's like, an unborn child, unborn calf. They always give this example, or something that has not come into practice or existence. It should be valuable. We mentioned that. It should be usable, right? So you can use and benefit from it. Capable of ownership. Again, if something you can transfer a title of. Capable of delivery, possession. Just want to highlight one thing here. We always say that possession is of two types. There could be physical possession, so I can give you my mobile and you take possession of it. Or, if we're not here, and say Brother Farhan wanted this mobile from Dubai, he was telling me earlier, as long as the person puts that mobile in a safe place where he has access, or to a friend that is his brother or sister, then that's still possession, because he has access to that, he can take that. So remember, it's constructive or physical. Specific and quantified, we mentioned that seller must have title risk. We've spoken about the price should be quantified and ascertainable, and that is basically, let's say we're talking about Turkish lira, what is the currency we're using, how much are we talking about, the fixed amount, because the more you leave that open, then the more gharar comes into it, the more kind of disputes arise. We've spoken about the delivery. There are 10 rules of sale. How much time do I have? A minute, 2? 5 minutes, inshallah. Yeah, I'll finish, inshallah. So 10 rules. These are very easy to remember. If those of you who want to really get involved in this subject, I would say that you should study our Sheikh Takî Osmânî's book Introduction to Islamic Finance, and also Dr. Imran's book of Mizan books, Guide to Islamic Finance, Islamic Banking. They have this in detail. It's because you can't learn something just from bullet points. You have to go and read the actual text. And then I would say that you should attach yourself to an Islamic bank, because you will see these practices on a day-to-day basis, or Islamic fund, an insurance company, because then you will really realize theory is one thing and practice is something else, because then you can really appreciate that. I can study all about how to buy and sell a house, but until I don't do conveyancing, real estate, residential property sale, commercial, I won't know how stamp duty is done, when do we sign contracts, what happens to various things. Rule number 1, subject of sale must exist at the time, we mentioned that. Subject of sale must be in the ownership, we mentioned that. So this is kind of repetition of what we've said earlier. Those were conditions, but then these have been summarized in a way that probably a bit more expansive on that previous one. Subject of sale must be physical constructive ownership. An example there for you. Sale must be instant, absolute, we've mentioned that earlier. Subject of sale should be an object of value, it should be mal mutaqawwam. It shouldn't be something that cannot be used or traded. Subject sale should not be a thing used for haram purpose. Subject sale should be specifically known and identified to the buyer. The delivery of the sold commodity to the buyer should be certain and should not depend on contingency. The certainty of price is necessary, and the sale must be unconditional. All those conditions I mentioned earlier, the 4 conditions of validity and what makes it void, all of that has been neatly summarized into 10 rules. So this isn't something different from that, it's just been summarized in 10 rules. you won't find these rules in the book of fiqh in this order. Yeah, so if anybody wants to go into Hidayah or any other book of any school, of Hanbali school, you're not going to find these conditions in a particular order. What they've done is summarize for ease. And what you will find is what makes a condition void, what makes a condition valid, what makes a contract void, what makes a contract valid. These are the conditions, but they have been put together in a rule form here for you, for your ease of understanding. You know, so you can always fashion it in any way you like. Something we'll just finish with, I touched on this earlier, a promise is something else and a sale or a contract is something different, right? So sometimes if something is problematic in this Islamic banking in practice, as opposed to theory, something is problematic, what they tend to do is say, okay, we'll have a separate agreement which isn't part of, and there's no reference made in the main sale and purchase agreement or the main master agreement, but they will do a purchase undertaking. Or they'll do a sale undertaking. That is done separately. So you can then appreciate, because if you have the two together, it will be two contracts in one. Or what you're trying to do is, are you selling? Are you buying back? What are you doing? So it confuses people. So what they do is keep the two separate. I mentioned earlier what is promise really binding, how do you make it binding, all of that is discussed here. Yep, and there's an exception to the rules we mentioned earlier in terms of, remember we said they should be in ownership, they should be constructed. Well, there's two contracts, Bay Salam and Bay Istisna, where it relates to, you can use this in agriculture industry, you can use it in the manufacturing, construction industry, these contracts which Sharia allows, and they have been in practice. Salam was in practice before Prophet ﷺ even went to Medina. So, and these things are there. I mean, we could look at this, how it's used, but that's not my topic, talk about the application of that. Yep, we've kind of covered that. So, Jazakallah for your time. I will leave it there, and if there's any questions, I'm happy to answer those later on. Jazakallah. Assalamu alaikum.